Hi guys, Alena Shautsova, immigration attorney from New York is here, and we're having our live last one before Christmas, which is tomorrow is Christmas Eve, and then there will be Christmas. So if you are someone who is celebrating Christmas, Merry Christmas to you. If you're someone who does not celebrate Christmas, Happy Holidays. Thank you very much for joining. Please save your questions. I'm going to talk to you today about options for those who overstay their visas or for those who actually never had a visa and are still residing in the United States. We're going to discuss what is possible. Of course, I'm going to talk about general reliefs and what typically can be done, but not every situation is exactly the same, as you may be aware. Probably every lawyer that you met would tell you that your unique circumstances may really affect your eligibility for various reliefs. But nevertheless, we're going to talk about what can be done. At least it will give you a good idea what to research, what to look out for. And let's start. Well, thank you very much for joining me again. My name is Alena Shautsova, immigration attorney from New York, helping people in all 50 states and overseas. I help with all types of immigration issues, visas, adjustment of status, naturalization, appeals, and so on and so forth. So stop by, say hello. Hi, Jose. Tell me, please, where you're watching from. Hi, привет. Hi, Pina. And don't forget to save your questions. You will post your questions in the chat that we have, and then I will go back to it and we'll answer them. Hi, me too. Nice seeing you guys. So basically, I know that Queens is nice. I used to live in Queens. Queens is good. So I know that many of you are very disappointed in recent news. In recent news, that said parliamentarian did not approve Plan C or plan that Democrats had for reconciliation provisions. Well, of course, we do not know what's going to happen next. There is a great possibility that immigration reform may still happen one way or another. Of course, they may still refer back to some plans that Republicans had a couple of years ago, which now don't look that bad at all. And at that time, Democrats were like, no, we don't want that. I remember that 3 Republican senators came and they introduced some act that would give pathway to citizenship to dreamers. And Democrats said, like, no, we do not want that. It doesn't include everybody. Well, guess what? Now nothing includes everybody. And we're still where we're at, like 5 or 6 or 8 years later. So let's focus on something that, realistically speaking, you may be able to do even without the immigration reform, right? Depending on your situation. Let's first of all talk about overstays. Generally speaking, if you're overstay and there is nothing pending for you, like asylum pending, so you don't even have hope for winning your asylum claim, you would need probably a family member in the United States to qualify for anything. Why? Because what happens is that for majority of people who overstayed their visas, they will not be able to get adjustment of status or a green card in the United States if they lapsed their status. Why? Because there is a provision in the law 245C that says that if you would like to file for adjustment of status or green card in the United States, you must demonstrate that you've been residing here continuously in lawful non-immigrant status. For that reason, somebody who overstayed their visa will not be able to get a green card based on a diversity lottery or based on employment petition. You won't be able to. And even if your spouse is a green card holder only, you still will not be able to get adjustment of status or green card. Only if you would qualify as an immediate relative of a US citizen, you will be able to adjust your status if you can show that you entered the United States legally. For example, you married a US citizen and you have a real marriage. Or you are a parent of a US citizen who is 21 years old. Then, of course, this overstay will be automatically forgiven to you. That's how it works. Automatically will be forgiven to you unauthorized employment. There is no reason to conceal your employment in the United States if you are filing based on marriage to a US citizen. I've seen some cases, not mine, but some cases that were denied. Why? Because it's not okay, but it will be forgiven to you if you work without authorization and now your US citizen spouse is sponsoring you. But if you do not put the information in truthfully in your forms, on your forms, an immigration officer will find out, and of course you should be truthful as well also, that you worked without authorization. Now you will be accused of committing misrepresentation and fraud, and you will have to also file for the waiver. So it's silly. It's silly to do that. I've seen this happening to people who were using paralegals to submit their adjustment of status cases to USCIS. And those paralegals got them into a lot of trouble where any lawyer would have consulted you and would tell you that it's just silly to put yourself in this situation by trying to conceal the fact that you worked without authorization, because it's automatically going to be forgiven to you. But if you don't disclose, you're going to be committing fraud. This actually works against you. Very interesting, right? So if you overstayed, that would be the usual cure, right, to get a green card. Cancellation of removal may be an option for somebody who overstayed their visa for a very long time and stayed here for 10 years at least. But you guys also will have to have a qualifying family member. Qualifying family member would be a US citizen, a lawful permanent resident, spouse, parent, or a child. A child is somebody who is under 21 years old. These are the people you need to qualify for cancellation of removal. Of course, these are not the only qualifications. And the interesting part with the cancellation of removal, you have to be in removal proceedings, that cancellation of removal, to be able to benefit from this relief. It's like a green card with a judge, yes. It's like a 10-year green card, yes. Some people refer to a 10-year green card, meaning that you have to reside in the United States for 10 years. But also you have to show extreme hardship to your qualifying relatives that I just mentioned. You have to be able to demonstrate that without you, these qualifying relatives are going to experience exceptional and unusual hardship. Also, that in the discretion of the court would like to give you this relief. It's adjustment of status, or a little bit different procedurally than adjustment of status. That's why it's called cancellation of removal. But if you file for it, you will see that the receipt for your filing is actually going to say application for adjustment of status. Very interesting. And of course, you will have to show that you're a person of good moral character, that you do not have certain criminal convictions. Extremely, extremely important. So this may be good for some people who's residing here for a very long time, but because it can be filed for only in immigration court, there is always a risk that judge may deny it and you may be deported. Another negative part with the cancellation of removal is that even if it's granted, it's going to take 2-3 years for you to actually receive your green card, because there are so many people who are filing for it, and there are only 4,000 of them per year. So there is a huge backlog, right? So that's how it works for people who overstayed. There are, of course, some other options which less frequently seen, I would say. For example, a visa for victims of crimes in the United States, guys. It also can be applied for family members of the victim of a crime. Sometimes you can file for the U visa if you are a bystander who got affected by the crime. Rare situations, but possible. Sometimes you can file for the U visa when it's not even you or your spouse who got hurt, but your child. Very, very interesting situation with those U visas. And U visa is very, very forgiving, meaning that it forgives almost all immigration violations, overstay, repeated crossing of the border. Some reliefs will not allow you to get status in the United States in these situations, but U visa will. Of course, the other negative part of this U visa that also there is such a huge backlog. You probably know if you're one of those who filed for the U visa, you're probably still waiting for employment authorization, which only this year USA has finally stated that they're going to give out employment authorizations for those who are in process of the U visas. And to my knowledge, only those who filed for their U visas in 2016 and very early 2017 are going to get those invitations or bona fide determinations to file for the U visa related work permit, but it may be an option. Some people do not know about T visa or visa for human traffickers status. It's I had a couple of those cases. Usually you have to show that you became a victim of what's called a debt bondage. When somebody brings you here and then you have to work for peanuts and you are in debt for before that person, it's human trafficking, horrible situations, but it's possible to get a relief in the United States and a status if this is you. Human trafficking does not necessarily mean that the person who is your trafficker transported you from country A to B. It also may be related to severe labor violations too, guys. Very, very important. And of course, I wanted to mention for the U visa, sometimes when you're a victim of serious labor violations, you are not being paid minimum wage, you're being abused at work, you also may be able to qualify for U visa. Very important, right? So we talked about adjustment of status, cancellation of removal, U and T visas. Of course, there are some other minor things. Here, I would mention probably VAWA. VAWA, and I have a good blog and video that I've done previously, VAWA, Violence Against Women Act. VAWA can be used by those who were married to somebody with a status, but that somebody with a status either, didn't want to sponsor them or abandon the process or does not want to participate even after they started the process. Let's say they say, oh, I don't want to prepare for the interview with you, or I don't want to go with you for the interview, or you're just simply tired of the situation and you don't have to stay in a bad relationship like that just to receive your documents. VAWA may be a good option for you. Violence Against Women Act, but can be used by men as well. Keep repeating it, and apparently still some people do not know that. VAWA can be used by men as well. Very, very important. Even after divorce, you can still file for it, but you will have 2 years, okay, after the divorce to file for VAWA. Very, very important. If more than 2 years passed, in most situations, you will not be able to qualify for VAWA. So it can be an option, all right? It can be an option. Sometimes you may qualify for certain reliefs if you were married to somebody before who qualified for it. For example, 245I, very interesting grandfathering provision in immigration law. And this will be probably the last thing I'm going to be talking about. 245I, and I have a good article about 245 adjustment of status on my website. If you were married to your spouse who was a beneficiary of qualifying petition, meaning it was a petition that was filed for them prior to April 30th, 2001, and you were married to that person prior to April 30th, 2001, later you got divorced, you may still be able to benefit from that 245I provision, even if later you got divorced from that spouse who used to qualify for 245I. So we really need to know sometimes when people ask me, can you tell me if I will qualify for something? I really need to know about your previous relationships and if that person got the status and how, or if they didn't, why not? Because it all sometimes matters when you are trying to understand and assess person's situation. And we always have to look at the records. It's very, very important. People sometimes, why do you need to see my files? Well, I need to see your files. Not only just some files, I need to see all of your files. All of your files. From CBP to see how exactly and when you cross the border and what you said when you were crossing the border, from immigration court and from USCIS. And every lawyer would, to my knowledge, a good lawyer would require the same. Because without the files, just like doctor without the results of the tests, may make a mistake. And those mistakes, as grave as doctor's mistakes, right? So these are the usual things a person may qualify for without the immigration reform, right? So without the immigration reform, very, very important. You can play this video back after we're done. See if you think it may be you. You can go to my website and see if that may be you. And of course, then please, you can call our office. We're going to go over your case and see if, in fact, it can be you. And now, guys, if you have questions, I'll be happy to answer them. Let's see. Let's see what we have. Hi, John. I'm from New York. Now the BBB is dead and I overstay my visa. I lived for 11 years. All right. So first of all, I'm not really 100% sure that BBB is dead. I do not know. How do you know that they will not try to overrule the Senate parliamentarian? I know that some people say that Manchin, this and that. Guys, these are politicians. Unless I hear from them that it's dead, I will not make any representations. Will not make any representations. Once they close the budget law and they vote on that, then, and it does not include immigration reform, then I will say, yes, it's dead, at least for the reconciliation provision. They always can negotiate with the other side. They can always come up with something else. President can have an executive action. DHS may also issue regulations, just like they did before. So we're going to see what happened. If you overstayed for 11 years and you've never been called to immigration court, cancellation removal may be an option, maybe, depending on the situation. If you'd like to take that route, I don't really recommend it as a first option to anyone, but it's a possibility, and all the other things I spoke about. Perhaps it's you, perhaps it's not. Hi, Kalinas. My wife has overstayed for 3 years and returning to home country not an option. All right. What is your status? Do you guys have any status? One thing I wanted to mention, by the way, it's I-601A waiver, which is very, very important. This waiver can help those spouses of U.S. citizens and permanent residents who do not have a legal entry. Let's say you entered the United States by crossing the border. That would be the reason when you would like to look into I-601A waiver, or you are a child who was brought to the United States. Dreamers often use this particular provision if they do not have any other means to demonstrate they entered legally or with advanced parole, right? I-601A waiver. Hi, Miguel. Is it section on Build Better Back still in the bill even with the reform out? I do not know what the section that you cited has. I really do not study the BBB bill by heart. I would only think that when the Senate parliamentarian spoke about the immigration provisions, I think she said no to all of them, but I may be wrong. And again, we're going to see what's going to happen with that. And I'm sorry, but I don't remember what section 60003 stands for. I really usually don't memorize the laws. There is really no need for that, Hi, Obeng. I was in asylum removal proceedings and the judge terminated my proceedings so I can benefit from this. I only have my uncle who's a US citizen. Can I qualify for this? What this specifically do you refer to? Please let me know. Also, are you sure that the judge terminated your proceedings and not administratively closed your proceedings? Because if the judge terminated your proceedings, it means you're no longer in immigration removal proceedings, right? And if the judge administratively closed your proceedings, it means that you are still in immigration court proceedings. It's only that the proceedings are not active. Two huge big differences, okay? Administrative closure allows you to still benefit from the employment authorization that you probably qualified for when you filed for your asylum case. Termination means your employment authorization is over and dead. So if I had to guess, I would say that your case was administratively closed because that usually would happen. Usually a person who filed for asylum or removal, unless DHS made some serious violations, committed serious violations of your due process rights, the judge would allow you to administratively close the case so you can keep employment authorization rather than terminate the case. They would terminate the case usually only if you would also qualify for adjustment of status. But if you only have your uncle is not close enough relative to qualify for cancellation removal or for waivers. Okay, uncle is a distant relative, unfortunately. Hi, Pina. Enter with J1. Doesn't have 2 years rule. Highly educated, clean record, and overstay. What's option to become legal again? I just spoke about those options. You can play the video back after we're done and see. As a rule, as I said, you will have to demonstrate that you have a relative in the United States or that you became a victim of a crime. Of course, it's a horrible situation, but the laws will protect you in this situation when you're a victim of a crime and will allow you to stay in the United States for the entire process. And the process can be lengthy. And starting from this year, you will also be able to enjoy or receive a work permit. Hi, Victoria. Any updates about withholding of removal status? Can adjust status. Hi, Victoria. Withholding of removal status. What happens with that is this: it's you were really deported by the judge. There is an order of removal against you, or deportation, and the judge withholds the removal. Right? According to the rules, the judge actually may lift this withdrawal. It's very interesting, but by itself, the status does not change. It's not going to change. If your circumstances change, for example, you would qualify, apart from this order of removal, you would qualify for adjustment of status. You may speak to your attorney and see if you would like to go back to court and try to reopen your case and file for adjustment of status, right? But withholding of removal is not really real status. You are allowed to stay here. It's more like a deferred action, I would say. Hi, Huma. I'm in asylum proceedings in February. I'm going to marry with a U.S. citizen in January 24th. What will be my decision? Your asylum case is not going to be directly affected by your marriage. Unless, of course, your asylum case is about something related to your marriage. Now, if you also qualify for adjustment of status, if you're marrying a U.S. citizen, you can file for it, right? And if you receive adjustment of status, usually your asylum case is going to be closed. Why? Because you no longer fear that you will be sent back. That's how it works. In fact, if it all happens before you transfer to court and you receive your green card, USCIS may on its own close your case, or you may write to them saying that you would like to withdraw your case at this point, the case to be dismissed or closed because now you have status in the United States. But I would suggest that you talk to your attorney, okay, or any lawyer who's going to go in detail, and of course will first review your asylum case, and then we'll advise you on the steps and how you're going to be handling the situation. But absolutely, it's possible to receive your status based on marriage. In fact, I have a video about this. When you have asylum pending and now you're married to a U.S. citizen, rather than pursue your asylum claim. Yes. Hi, Nurik. I applied for asylum in 2015 and missed my interview in 2018. And I also didn't show up to the court. Why? So the judge ordered removal. Yes, they will. Which I didn't know. Is there any chance now to change my status? Well, the question will be why you did not know what happened. If somebody missed their court without knowing that there was a court date, and your record shows that, right? Maybe the notice was sent to a wrong address. Maybe it was sent to your lawyer, and lawyer never informed you about all those dates that you missed. It's possible to reopen your case. But without reopening of your case, you have that order of removal by default standing against you in your way to any possible status, unless, for example, you qualify for a U visa. So, consult with a lawyer, order your immigration files from the court to see what happened. That's missing your court date, guys. It's not a good situation. So I know sometimes I meet people, they say to me that lawyers tell them not to show up, which is crazy, because if you're ordered deported, just deported, yes, it's going to be unpleasant and you're going to have an order of removal against you. But if you do not show up to a court date that you knew about, in addition to the consequences of not showing, of having order of removal, you're also going to have a 5-year permanent bar, for which there is no waiver, unless you can show that you had a good reason for not showing up to court. What it means, for example, you have an order of removal. You still may qualify for I-212 and I-601 waivers if you marry a U.S. citizen, for example, or your child reaches 21 and sponsors you, right? And you have a qualifying relative. Usually it happens when you marry somebody. But if you missed your court date without a good reason, those waivers will be useful. Because the minute you leave the country for 5 years, you will not be able to come back because of that permanent bar, you see? So it's bad idea to not show up to your court date. Usually bad idea. Always actually a bad idea. If you know you cannot make it, write a motion, ask the court to transfer the date. Courts usually very flexible, I have to say. Sometimes I read decisions when the judge would refuse to transfer the date, to change venue, but I'd say it's rare. It's possible, but rare. Hi, Duke. Can asylum pending interview adjust status for DV lottery? Admitted on B1, B2, but applied before I-94 expired. Well, you can go for it and try and see and let me know what happens. There is one case, matter of LK, right? Board of Immigration Appeals, where lawyers say that it may work for this particular situation. I personally have not handled cases like this because I consider them risky. And but you can try. You can try, depending also where you live. According to American Immigration Lawyers Association board, where we talk between ourselves, like lawyers speak to each other, in some jurisdictions it does work, and in other jurisdictions it doesn't. So I would say that, what do you have to lose? They're going to deny adjustment, saying that asylum pending is not lawful non-immigrant status. If you do it yourself and you don't pay money to a lawyer, or if you assume the risk and you would like the lawyer to take your case with very clear understanding that it may not work because of the reasons that you failed to maintain your lawful non-immigrant status, and you're going to be arguing an exception to that, go for it, Hi, Alena from Houston. Any news about BBB for undocumented immigrants? Immigration news? So far, not. I know that there is a lot of negative news. I refuse to read them. Why? Because nobody knows what's going to happen. I do not know. Maybe tomorrow we're going to wake up and we're going to have a different reality. We do not know. You always have to stay positive. Negativity kills your health. That's one thing I can tell you for sure. So, no, we don't have any news. I don't think we're going to hear anything until January. Why? It's because they're going to be voting on the budget. So when they're going to be voting, you really have to more listen about when they're going to be voting on the budget. That's going to be your real time deadlines. Because before that, it doesn't matter what they say, honestly. It doesn't matter. Also, remember, they're negotiating other points. BBB is not only about immigration. They have other controversial points that they're fighting. So it's very, very possible that they're going to be, changing something. Hi, Jesus Rivera. Thank you very much for the sticker. I have TPS arrest for traffic tickets. They dismissed my 2 cases. Can I travel with advance parole and come back to the United States? I would say that you can if you have those records and those tickets dismissed. Okay? Take the record with you, please, when you travel. But as a rule, traffic tickets don't matter. They're too small to create any problems for you. And especially if you have a TPS. TPS is a very forgiving status, I have to say. It really is. I've never seen anybody with TPS being stuck overseas. Even I had one case, it was very interesting. The lady on TPS left and she forgot that her advance parole expired. She also had with her a 7-year-old child who was a US citizen. So she got stuck in her home country and we had to bring her back. I had to involve senators and USCIS, and eventually we were able to reach the consulate in her home country. And I called them and say, listen, why don't you give my client the advance parole? She needs to come back home, and her little daughter is missing school year. And they told me, like, listen, we told her to come back for fingerprints so we can give her the advance parole. And she told us 3-hour drive is too far from her for her to drive. I called her and I said, you gotta be kidding me. We fought for your advance parole in basically against all the rules for 3 months. We finally found the people who said that gonna do it for you in the consulate, the United States consulate overseas, and you cannot travel because it's a 3-hour drive. Well, eventually she did understand that it was a huge favor the United States consulate was giving her because they didn't have to. They did not have to. But for the sake of her little daughters, they were very nice. And she was able to come back even though her parole lapsed completely. Thank you, Jesus. So you should be able to come back, okay? Just take the records that you paid. Take the records that you paid. Hi, Dilshad. Good evening, attorney. I have been given withholding of removal status. Now I have a chance to adjust my status and apply for green card if something will change in January. If something changes in January, guys, depending on what's going to change, you may be able to. Very interestingly, when I was reading those proposed laws, what I found is sometimes they specifically mention that if you have an order of removal against you, it will be automatically canceled if you qualify for the new relief. So I hope that if they will be passing some immigration reform, they will also make it very clear so we as lawyers and judges and prosecutors don't have to guess what effect this or that status is going to have on orders of removal. But generally speaking, if nothing changes with immigration, right, and laws, if you have a withholding of removal and now you can adjust status, let's say you marry a US citizen, you will have to go back to court. All right, you have to go back to court, usually if USCIS does not have jurisdiction over your case. In certain situations, when you are labeled as arriving alien, even though you're in immigration court, you may still adjust your status with USCIS. It's crazy. Sometimes, though, you may choose a different route depending on your situation and allegations against you. Sometimes you may have a better luck in immigration court than with USCIS because USCIS, they're kind of not flexible. I'll be honest with you. If they have a policy in the office not to accept waived in. Waived in, for example, is when you're in a car with someone else who's a US citizen, right? You're crossing through the border and the CBP is asking you, let's say you're coming from Mexico and CBP is asking you, guys, everybody's a US citizen. Your US citizen friend shows them their passport and says, yes, CBP does not check you. Guess what? You entered the United States legally. I know it sounds crazy, but they waived you in. They inspected you and waived you in. Some jurisdictions are very clear that if you can present credible evidence of that happening, it's like you have a legal entry and you can adjust status in the United States. And some jurisdictions like New York says, no. Okay, it's crazy how it works, but you really need to know if your jurisdiction is for it or against it, and it's, I don't know why, but it changes from place to place, depending on perhaps federal court's rulings in the area. So yeah, when it passes, we will know better. And I'm gonna tell you, it's true for everything. It's very hard to comment on something that has not become the law yet, because as lawyers, we do not know the legal effects of it. Hi, Striker. I love your videos. Thank you very much. I watch almost all of them when they come out. My overstay sister is marrying a US citizen. What's the fastest chain migration path for my parents and who overstayed? All right. So you can sponsor, one can sponsor their parents only when they become US citizens. No. Only a US citizen can sponsor their parents. This is a better way to put it. A lawful permanent resident cannot sponsor their parents. Why? I do not know. But that's the law. So the fastest way would be probably if your sister is very successful in getting her documents based on marriage to a US citizen, and then she's very successful and fast in getting her citizenship in 3 years after she becomes a green card holder based on marriage to a US citizen, and only then she'll be able to file for her parents. That's how it works, you know. Yep. How, George? Good afternoon. I have a cousin who came to the United States when he was 3. His DACA application was frozen because of the Texas ruling. How long until we hear new info on appeal? Guys, really do not know because of all these procedural situations and stuff. But I do know that DHS drafted new rules about DACA. So I think what's going to happen is that they're going to say that maybe they will try to argue that now DACA should be um, continuing based on the new rules and not governed by the old rules subject to Texas litigation. So I really do not know, but we'll see what's going to happen. I wish I had better information on that. Also, with appeals and everything, it's like you can probably see when the schedule is for the case on appellate website. It's a public information, but what's really going to happen, we all do not know until it actually happens. Hi, Flo. I overstayed my F1 visa with duration of stay on my I-94. What are my options? Sister applies green card for me. My sister, US citizen, applies for green card for me. And this will be the last question I'm going to answer today. Somebody who overstays F1, J1, or other visas that are given for duration of status actually in slightly better situation than some other people. Why? Because you guys do not start accumulating unlawful presence time unless and until USCIS is going to send you a letter saying your status terminated, you have to leave the country, right? And very often it doesn't happen. It means that if you are going to have a qualified family petition in a qualified category, meaning that you're not an immediate relative. Let's say a sister or brother files for you, you know it's going to take about 8 to 10 years for the petition to be ready. And under the current laws, you will not be able to get a green card in the United States. You will have to leave the United States and come back. But someone who overstayed F1, J1, and so on will be able to have a visa issued to them in their home country and come back without the waiver, because you will not have unlawful presence time. Unless, of course, something crazy happens. As I said, those letters, or maybe you tried to change status to B1, it didn't work out. Important piece of information. It didn't work out, then you will start to accumulate unlawful presence time. All right. But other than that, you may have a chance of getting a visa and coming back. But still, it takes 8 to 10 years, unfortunately, because it's a siblings immigration F4 category, one of the longest category in the family-based petition. And of course, it also depends on the country you are from. So check out the latest visa bulletin. So guys, thank you very much for watching. I wish you all happy holidays. I probably will see you again before New Year's, because because I miss you guys, you know. But if you are celebrating Christmas again, Merry Christmas. And if you're not, it doesn't matter to me. Still happy holidays. Hope you're still going to have time off and good time with your family, friends, and whoever you choose to celebrate your weekend with. Of course, I feel like this year we got cheated because the holidays fall on weekend. But nevertheless, thank you very much for watching and joining. I hope you are going to have a very peaceful, nice, and restful holidays. And don't forget to sign up, subscribe to my channel if you have not done so yet, so you will be able to join our next live and ask your questions, which I am always happy to see and answer. Thank you, guys.